matter. He's being held now, no bail, in the Eastern District of New York and in the Northern District of Illinois. Unless Mr. Greenberg can convince both of those courts that he should be released on bond, Mr. Kelly's going to remain in custody. So as far as a motion to increase the bond, I don't believe it's appropriate at this particular point in time. That being said, if there's a change in circumstances, in other words, if you're able to convince both of those federal courts in those different jurisdictions that he should be released on bond or some type of conditions regarding release, if you want to bring that motion to increase the bond back before the court, I think that would be appropriate. But at this particular time, it's kind of a moot point. The bond that was set originally in this matter by the, I'm assuming the bond court judge, or maybe from the grand jury, I'm not sure. Bond court. Bond court? Okay. I thought when the case first came before me for arraignment that the bond was adequate based upon the fact that there's 4 cases, there's $250,000 D bond on each one of the cases, plus pretrial services, which I thought was appropriate based upon the information that I had regarding Mr. Kelly. I still believe that's true. That being said, I'm going to deny the motion at this particular point in time. If there's a change in circumstances and he is somehow released from custody and you want to bring it back before me, I'll take a look at it then, okay?
Good afternoon. So that was a judge in this case of Illinois v. Robert Kelly about a year ago where they first decided the bail requirements for Robert Kelly. Not much has changed, but he did leave the door, as you do for any defendant. If there's a change in circumstances, then the defense counsel can come forward and ask for a modification of bail. In the last argument, because there have been many for Robert Kelly, the argument has been that because of his inability to read and write, sending court documents, as many defense attorneys do to their clients, to be able to read what the state or the federal government has against you and be able to participate meaningfully in your defense, as the Sixth Amendment in so many ways argues, is being hindered because of COVID-19 and Robert Kelly's inability to read court documents being sent to him. So for that, they're asking for to be released. Now I'm joined with Jennifer Shen and Judge Birmingham. Let's talk about this because this one's interesting. Jennifer, let's start with you. We all know the Sixth Amendment. We all know right to counsel. We all know that there has to be a meaningful participation between defendant and defense attorney. This one's a little odd to me. I'm not quite sure how I would rule on this if I had to argue it. What are some of your thoughts on it?
Well, my thoughts are it's very, very important to give defendants the ability to prepare for their trial, and they need to have contact with their lawyer, and they need to be able to assist in their own defense. So what I'm surprised by is they haven't figured out how to do that for him. If you can't read and write, clearly the traditional things won't work, but why could they not set up a Skype or a Zoom or some sort of teleconference where the attorney and the client could then meet virtually? I would think that would be something that would alleviate this particular problem.
Yeah. Judge Birmingham, is this a situation where we've got to get a little creative? Because I get it. If COVID-19 wasn't there, we would just be able to go into the jails or the prisons and be able to speak to our client. But like Jennifer is saying, maybe we got to get creative. Maybe we have audio-like books for the court materials that are sent to R. Kelly so that he can listen to his court documents rather than having to read them. What are your thoughts?
Well, I think that the first thing you got to make sure is that the defendant is properly prepared for the trial. That's one of the components of this effective assistance of counsel. So you got to be creative, like she said. Video conferencing. I know I've opened my courtroom up where we are allowing inmates and their lawyers to consult on occasion. I can give them my courtroom. It has the full capabilities to look at videos if need be, or look at pictures, or they can bring in their documents, they can bring in their laptops and work off the Wi-Fi. So you're looking for those measures that are creative to give them the access while keeping in mind the reasons why you, as the judge, set the bail in the first place, which is taking into consideration things like whether he's a flight risk or poses a danger to the community. And certainly that's some of the things that the judge is considering, going to consider when making this decision.
Yeah. When it comes to this bail argument, Jennifer, I'm thinking about it as a defense attorney, you're really between a rock and a hard place because, like the judge already articulated, being a flight risk is a major component as to whether or not bail is set, and especially the amount of bail. R. Kelly and the nature of these charges kind of makes him a flight risk. It's hard to argue otherwise. But that hard place of being able to prepare with your client, let me be a little bit as a devil's advocate. I've got state cases that are 400 or 500 pages. I can't imagine how many pages his case is. How would I be able to sit down and communicate to my client 600 pages of documents in a way that they understand? That seems almost impossible. So how would we do that?
Well, I mean, I understand that, but as we all know, look at how we're doing this. I mean, everybody who's running corporations, having meetings, coming up with plans, setting vision, doing HR, everything is being done online now. It can be done. And it's just a matter of making those tools available to those that need it. So I think that a video conferencing sort of situation where he could speak to his attorney in real time for as long as necessary to understand the documents ahead of and put in front of him, I think would be the way to go there. And I agree. We have to remember what the crimes alleged are here, and a flight risk is certainly a real possibility. And I mean, that's really not an option to allow that to happen, in my opinion.
Yeah. Understood. Let's take just a little switch of the gears. Let's go down to Mississippi and talk about another case we're following, that of Curtis Flowers. He was tried 6 times, count it, 6 different times. And after the 6th time, the state of Mississippi has decided to dismiss the charges against him. But he spent over 2 decades, about 23 years in jail during those 6 times. Let's break the 6 times down. It appears the first 3 times were overturned by the state Supreme Court, meaning he was convicted 3 for 3. And because of some appellate issue, it went back down to the state district court, and they said retry the case. After those 3 times, 2 trials were a hung jury, meaning that they could not get a unanimous decision one way or the other. On the last trial, it went all the way to the United States Supreme Court, and they decided that based on the case is called Batson, but based on the fact that people were selected or deselected is probably the better way of saying it, based on a protected class, whether it be race, gender, religion, or creed, that a jury was constructed illegally based on that Supreme Court case called Batson, and that the whole case had to be redone. Instead of redoing it, Mississippi said, you know what? We thought 6 time would have been, or 7 time would have been the charm. We're not going to go forward. And yet now he is a free man with those charges dismissed against him. Judge Birmingham, first, have you ever done 6 retrials or 5 retrials? I mean, let's start there. How crazy is this to you?
I mean, you know, I think the most I ever did as a prosecutor was 2. So 6 is an extraordinary turn of events for Mr. Flowers. And it was reversed on Batson. And that case is a fascinating study on Batson and the way that they viewed it. They didn't just view the one trial, they viewed all 6 cases together, which I think makes that case in particular pretty interesting when you're trying to discern whether or not a prosecutor or a lawyer used race as a reason, as a pretext for their strikes. You know, and now all these years later, they did not work out a plea bargain. He is, you know, a free man, and I suppose that those victims, this was a horrific crime. You know, there still are the victims, and so, you know, I'm wondering where the future is going to go for this investigation, if this case is really over, or if there's going to be some amount of closure for those victims.
Yeah. And Jennifer, it appears that part of the dismissal is also just the age of the case, because while he was in jail for 23 years, this alleged crime happened back when he was 26. They believed that Flowers had went to his old employer, shot and killed them for firing him, and then killed 3 other employees to kind of cover his tracks. But as that case progressed, those witnesses, those evidence deteriorated, people passed away. It became an almost impossible case, I believe, for them to try. And that's part of the reason why they dismissed the case. To Judge Birmingham's point, maybe this should have been something they resolved after the 4th or 5th try. What are your thoughts?
Yeah, I agree with you. And, you know, there is a reason that you try to get to trial as soon as you can. You want to make sure you have your witnesses. You want to make sure you have your forensic evidence lined up. And this case is over 2 decades old. The forensic evidence that was collected at that time may not have been tested in the way that it can be now. It may not have been collected the way it could be now. And so they're there likely isn't a lot of supportive forensic evidence to go along with the witness statements. So 20 plus years later, you're right, you don't have the elements that you need to prove a crime beyond a reasonable doubt and do it in a way that absolutely follows the law. And that's the concern here, is if it kept getting overturned, then there are things that were being done on the prosecution side that didn't absolutely follow the letter of the law, which is the cornerstone of our criminal justice system. You have to convict people beyond a reasonable doubt, and you have to do it following the law, doing it the right way, not turning the situation into that it isn't fair to the defendant. It has to be fair to the defendant. And I don't see how they can try someone so long later. I just don't think it would work. And I think after 6 times, I think you pull the plug, unfortunately.
Yeah, agreed. And just to highlight what you're talking about, Jennifer, because if you think about it, the only time they got convictions against Curtis Flower would have been 4 out of the 6. And each time that went up to a higher court, and the court said, no, you as a prosecutor or you as a judge, or both, did something wrong to get this conviction, and we're going to send it back for you to do it the right way. The only 2 times there were no convictions was when there was a hung jury. And of course, we in America don't convict someone unless it's unanimous. So it appears that this case had a lot of issues from even the beginning in terms of the inability to convict, absent some sort of legal impediment from someone, either whether it be the judge or the prosecutor. But now, Curtis Flowers, after 23 years of being in prison for these crimes, he's free. The case is dismissed, and it appears dismissed without prejudice, and he will not be retried. While he was incarcerated, he was attacked. There's another little tidbit as well by Jeremiah Shane Farmer, a convicted member of the Latin Kings, who outed him. Apologies. So after the trial, so he was found not guilty. He ended up walking away. I apologize about that little tidbit. But Curtis Flowers is now free. Mississippi has decided not to continue with that case. We'll be back with more. We're going to talk a little bit more about Todd Mullis. We've got Jacob Blake, as well as Robert Rudolph, the Olympic bomber, who's taking a few pages out of the Boston Bombers page to make some arguments about his case after this.
Yeah. I just want to say, man, to all the young cats out there, and even the older ones, older than me, it's a lot more life to live out here, man. Your life, and not only just your life, your legs, something that you need to move around and move forward in life, could be taken from you like this, man. And I promise you, the type of shit that you will go through, staples, I got staples in my back, staples in my damn stomach. You do not want to have to deal with this shit, man.
All right, so that's Jacob Blake, the young man who was shot 7 times in his back in Kenosha, Wisconsin. He's speaking for the first time after being paralyzed in that bed due to those shots in the back. Shortly after that, he was arraigned on the charges that stems from the initial interaction with the officers, that being domestic violence charges. He's charged with 3rd-degree assault, as well as trespass and disorderly conduct, the first charge being a felony, and the second 2 being a misdemeanor. Now, as we've heard reports in the past, he was handcuffed to the bed, even post-surgery. That was due to the open warrant, but once the warrant was vacated, that handcuff was taken off. I know for many people that is a jarring reaction, and I don't disagree with that being jarring at all, but that unfortunately is how much of the criminal justice system works, that people are handcuffed to beds during that time and period, something that hopefully can be changed down the line, especially considering the medical issues that they were having at the time. There was a $10,000 bail and a few requirements of Mr. Blake, that he cannot leave the state unless it's for any kind of medical needs, as well as obviously there are no violence to be had towards the alleged victim in this case, that a former spouse of his. Let's bring in our guests. Let's talk more about this. Judge Birmingham, I also want to talk a little bit about just like the pretrial stuff that already happened. So we've seen that in some states, I know for most of us, we think grand jury. A grand jury in panels, depending on the state, it's 12 to 20 people. They decide whether or not there's probable cause. But because of COVID, many states, mine included in New York, we've been doing what's called preliminary hearings, which are like mini trials. Jacob Blake actually waived his preliminary hearing. The judge found probable cause for the charges, so no need for a grand jury because COVID right now is going on. And we've set a date for a pretrial conference on October 21st, as well as jury selection on November 9th. Hearing all those kind of administrative things in the beginning, what do you make of this case as it applies to Jacob Blake, specifically to the DV case going forward?
Will be an interesting question about how much of the underlying facts and circumstances will be admissible in the trial of the officer, if there is going to be a trial of the officer. Okay, so what you've got to do is consider, at some point in the future, you're going to be looking at what is bearing on the mind of the officer at the time of the shooting, and all relevant facts and circumstances that are known are going to be admissible. Now, how much of the underlying facts and circumstances of the particular cases, what these warrants were for, that there's going to be a limit there, because at some point it becomes more prejudicial than it is probative. And that's the type of analysis that's going to come into the minds of the judge who's determining whether or not to allow some of this evidence in the trial for the officers.
I mean, Judge Birmingham, you hit every point I was thinking of. I don't even know if I can come up with a new question. But let me try, Jennifer. So Jennifer, let's use the judge's analysis, because I think that's on what a lot of people's minds right now. Everyone's kind of thinking about the shots in his back. We know that he has a criminal case as well. In my mind, for the most part, it's really about what the officers knew compared to what is the actual truth. Because if the officers knew there was a 911 call, and I think initial reporting is that the caller, we're assuming it's the complainant or the alleged victim, is simply saying, I do not want him to be here, and then was uncooperative, from my understanding, didn't really give further details. It would beg the question, as the judge is saying, how much information should come into that trial if the officers don't really know the full facts of what was going on when they came to the scene? How do you kind of balance that out or argue that either way?
Well, it's tough. It's tough. And separating out the DV charge from the officer's trial is also important, and both need to be handled individually as much as they can be, in my opinion. So as far as what the officers know, it is important to know exactly what they thought going into that situation, what information they had. Did they have information that made them fearful of a violent situation, either against them or the victim? It is important to know what their state of mind is to reflect upon how they responded at the actual scene. So I don't know what it is they knew, but I think that's a really integral part to deciding what kind of culpability an officer might have in a situation like that. But to me, all of that is separate from the domestic violence situation that should be a completely different, a different trial, a different set of information and facts. They should be separate from each other as much as they can be.
Yeah. I mean, you're going to see this play out if this case, as Judge Birmingham said, does get to a trial, that being not necessarily the domestic violence case, but that of Jacob Blake being shot in the back 7 times. Because for the prosecutor, you're going to hear words like, we have to complete the narrative. We have to explain to the jury why these officers are there. It's not that they just showed up and decided to commit a shooting. You've got to explain that to the jury. And that's one side of the argument. The other side, the defense obviously saying, well, as the judge pointed out, this is more prejudicial than probative. We have to be probative to some extent. We can't be so prejudicial that the cornerstone of our criminal justice system, innocent until proven guilty, is completely removed based on the information that we put here. It should be judged solely on what the facts are and what people knew at the time, rather than collateral information. That's going to be interesting to see how it plays out. And this DV case is going to give us a lot more insight into that Kenosha case as that develops as well. Let's turn ever so slightly, because this one's really interesting. This one, Judge Birmingham and Jennifer, I'm really going to have to dig deep into your brains, because this one is kind of spinning my head around as well. We all heard about the Boston bomber and how his case, in terms of the sentencing, is being reevaluated based on how the punishment was handed down. Well, Eric Robert Rudolph, if you remember him, he was a bomber in his own right, where he bombed the Atlantic Summer Olympics in 1996, as well as a nightclub that was predominantly used, or people who were from the LGBTQ community went there. And he also bombed, I believe, 2 abortion clinics. Well, after that arrest, he wrote a manifesto. We all knew who he was. We knew what he wanted to do. We knew what his mindset was. Well, now he's looking at the Boston bombers case and saying, hey, I want a little bit of that justice as well. And he's making similar arguments to have 2 of his life sentences vacated based on what seems to be an Eighth Amendment argument of excessive punishment, as well as the mens rea or the mental component to the charging instruments. Because what they're trying to argue with kind of makes sense is he didn't knowingly injure anyone. He was merely reckless in putting these bombs. I'm not sure how well that argument's going to fly, but it seems to be something they're hinting at. Judge Birmingham, let's bring you in on this one. A lot of moving parts. You're having one person who's already sentenced looking at another case saying, hey, that argument applies to me and I want to vacate. What do you make of this initial argument at first blush?
Well, at first blush, it does speak to the idea that our system should be set up so that we have equal treatment under the law and that the law applies equally to everybody. And if there's a law change in one area, and remember, these are all federal cases, so it's all the same penal code, basically. If the law changes in one area, if there's a light that shine on that particular law that impacts cases, even if they're already over and done with. And remember, the Atlanta bomber, he pled guilty already. He pled guilty in order to avoid the death sentence. He got 4 life sentences as opposed to a death penalty. And all he's saying is, hey, look, the First Circuit interpreted the law in a certain way, and I would like for that law to be applicable in my case. And if you apply that same reasoning, then 2 of my sentences should be undone. So it's not uncommon, it's not unheard of that the law, which evolves, that we should be relooking at all of the cases where the law was applied in a certain way. And if it's changed, we need to look at all those cases. It's only fair.
Yeah, and to the judge's point, Jennifer, this is I mean, for many people who grew up during the mid '90s, we know this story fairly well. First bombing at Olympics in '96, second bombing at an abortion clinic in '97, then another in Other Side Lounge, LGBTQ nightclub in '97, and then another all women's clinic in '98. He wasn't captured until 2003 by, of all things, a rookie police officer, and he did plead guilty in April of 2005 to avoid that death penalty. 17 years later, he's applying law and different interpretation to help vacate 2 life sentences. What do you make of that? Because like the judge says, the law is a living and breathing thing. It evolves over time, and defense attorneys and defendants are able to appeal based on laws that might retroactively apply.
That's true, and since I'm not a legal expert, I can only tell you how I feel as a, as a person having grown up during that time. I mean, these are very significant acts, and all of them appeared, or at least 3 of them appeared to make some sort of statement about his beliefs. And I just don't understand how you think you could plant a bomb and not hurt people. So it's tough for me when you make a deal to not get the death penalty and you agree, you plead guilty, you agree to the terms. It's tough to go back so long of a time later and sort of reassess that. I think when you plead guilty and you accept a plea, that's kind of what you're accepting as your fate. So while I'm a big believer and we need to be absolutely fair to everyone, and the law is a living, breathing thing, it's really hard to look at that and feel like that's the right application.
Yeah, and Judge Birmingham, this is the one that really got me. I don't think it's going to work. And it might not necessarily be what he did in terms of the crime, but what he did after the fact. His manifesto, the way that he articulated his desires to injure a very specific population of people, that doesn't seem like reckless to me in planting these bombs. It seemed very intentional. I would think that that's how he might lose on this appeal. What are your thoughts?
Well, it depends on whether or not that evidence is in the record. And I think, if I'm not mistaken, it was. But again, we're talking about the facts as opposed to just what the law is. And if there's a sea change, then we might have to go back now that we understand better how courts are going to apply a particular law and what facts go. And he may ultimately lose an argument. It certainly defies common sense to place a bomb in the middle of the crowd and say you don't know that you're going to hurt anybody. And the manifesto speaks volumes on that. But the law is very much a process, and he's entitled to due process.
Yeah. we're going to see how that plays out. It's going to be interesting. We're going to keep you on track with that one, especially the Boston bomber, because don't forget, that argument hasn't been settled yet. That's one that was merely raised, and that court says, hey, you know what? We will hear it, we will argue it, and we'll see how it plays out. But you better believe that if anyone's watching how that case plays out, it's definitely going to be Rudolph as he tries to make any kind of measure to apply that standard to his own, because this appeal actually came from him on an 11-page handwritten appellate motion to vacate those 2 life sentences, as I said earlier, with the thrust of the argument being it was a violation of the Constitution. I believe he's probably making the argument based on the 8th Amendment, as well as, quote, it's an excess of the maximum punishment that's allowed by law. Again, we'll show you how that plays out later on, but until then, we're going to take a quick break and come back with more here at the Law and Crime Report.
I did not do this. This is supposed to be America where you have a fair chance of proving your innocence. But you shouldn't have to prove your innocence. Instead of the other way around. I thought it was guilty until, or innocent until proven guilty. I feel this is the other way around. And I was a faithful and loving husband, and I never did this.
All right, perfect timing for the horn there as you hear Todd Mullis talking about his sentencing, where he was sentenced to life without the possibility of parole. However, as we clearly saw during that phase and the sentencing, he was asking for a new trial. Now, it might not have been the right venue to ask for that, but he did have some pretty compelling arguments. I want to make sure I get through all of the arguments as to what they're asking for a new trial. First, that the Deputy Travis Hemsmath, was not qualified expert for the purpose of introducing internet searches, that he also provided improper hearsay testimony. Also, the defendant's attorney did not go with the quote-unquote accident defense, which is against Todd Mullis's wishes, kind of making an ineffective assistance of counsel argument there. Also, the defendant did not inform him of his right not to testify. That's a major thing. You've got to tell your defendant whether or not he can testify. Of course, the weight of the evidence was contrary to the verdict. And the big one for at least me was the defendant never said, quote, cheating whore in the 911 call. And so referring to it was an error or prosecutorial misconduct. Again, I'm joined with Jennifer Shen, as well as Judge Birmingham. Jennifer, you testify so often as an expert, and you kind of talk to us about this. In testifying, I know that all the good ones, they say you only testify to what you can. You never want to reach too far. What did you make of some of the testimony, or just generally the idea of maybe reaching a little too far in your testimony as the defense is arguing happened here?
Well, I mean, there's a couple of things about testimony, and that we train our new scientists. Definitely don't reach. Again, we've talked about this before today, that the trial needs to be fair, and it needs to be fair to the defendant and fair to the victims. And reaching and having opinions that you're not really sure of, or entering evidence that you're not really sure of, or sort of circumventing just a little bit the rules of fair play in a trial, it's not right. If we're going to convict someone, we need to do it by following the rules every single time. So as a witness, you need to really be careful about that.
Yeah. Let's listen to the defense attorney's arguments about this in terms of asking for a new trial.
Whether or not Mr. Mullis received effective assistance of counsel during the course of this trial. Now, Judge, Mr. Mullis has always maintained that this was an accident. He has never come out and said that this was a murder ever. Second, he never told his counsel at the time that they could concede an essential element of a crime that Mr. Mullis has been accused of committing. And what happened in this case? Well, during the opening statement, the fact that this was a murder and the jury has to figure out who did it, was conceding an essential fact or an essential element that the government would have to prove beyond reasonable doubt to the jury. Now, that's important because there's a United States Supreme Court case, McCoy versus Louisiana. And in that case, the Supreme Court, under Head Note 6, goes on to say that numerous choices affecting conduct of the trial do not require client consent, including the objections to make, the witnesses to call, and the arguments to advance. The court goes on to say, though, that counsel in any case must still develop a trial strategy and discuss it with the client. The court goes on explaining why, a lawyer needs to say why, in their view, conceding guilt would be the best option. Because once an admission to a murder is made in an opening statement, you can't put that back in the bag. That's out. The jury's already believing that this was somehow a murder and that they just have to decide who committed it. Once again, the only way that we can right this wrong is to grant Mr. Mullis a new trial.
All right, so Judge Birmingham, I don't want to beat a dead horse with the 911 call, but let's circle back to it. Let's talk first about this one where Todd Mullis is arguing that his defense attorneys admitted to an element of the crime, that it was a murder, and he didn't want that. Now, the first thing that comes to my mind is that it's actually the defense attorney's ability to pick what trial strategy. A defendant doesn't have the ability to argue how a lawyer should or shouldn't argue a case. Do you think here, however, where you're admitting to such a huge component of a trial, that being that a murder actually occurred, that could be grounds for an appeal here?
Well, the case that he's talking about is a death penalty case, the McCoy case, where, essentially in order to plea for mercy in the punishment phase of the case, the lawyer said, that his client was guilty and sort of conceded guilt in that way. I'm not sure it's exactly the same thing in this trial. What this is all really going to come down to in ineffective assistance claims is what was the harm? What was the information that was shared between them in this strategy? Remember, we're only hearing from one person, obviously from him, in making this motion for a new trial. We can't do anything, can't decide anything until we hear from the lawyer. The interesting thing about ineffective assistance claims is that once they're made, you can waive that attorney-client privilege, and then perhaps some of these discussions will be brought back out into the open to see if there really was a lack of consent. So it's going to be a long way to go. We're right now just at the very, very beginning of this process.
Yeah. Now, here's the judge ruling on the issue for a new trial. Again, this might not be the best form for them because this was during the sentencing, but let's listen to the judge's ruling on the motion.
Mr. Hamrock, that you have provided a transcript of your client being under oath in a different proceeding, a probate proceeding, in which he did say, I did not authorize my attorneys to say those things. I understand that. But generally speaking, ineffective assistance is an issue that's typically dealt with on post-conviction relief. In this circumstance, based on the arguments that both parties have made, I do think that that is an issue that will have to be addressed on post-conviction relief. I do not find today, based on the record we have here today, that the defendant was deprived of effective assistance of counsel. The third issue argued today deals with the totality of the evidence, taking all of the evidence that came in and considering it in the light most favorable to the non-moving party, which is the state here, and defendant's argument that considering all of that evidence in the light most favorable to the state, it still was not physically possible for the defendant to have committed this act. Neither party has made any argument that the jury was improperly instructed. So we did have 12 jurors properly instructed on the law after a lengthy trial who unanimously agreed to a finding of guilt. Ms. Hughes recited the law as it pertains to the burden today and what I have to consider, and I think she properly recited the law. I would say I think that I'm actually required, or at least that I should, independently weigh the evidence and consider credibility as it pertains to a motion for new trial. If the verdict is contrary to the weight of the evidence, the defendant is entitled to a new trial. I cannot say that the evidence in this case, or that the verdict is contrary to the weight of the evidence. As to the defendant's motion for new trial and motion in arrest of judgment, I will deny those motions in their entirety.
Now, Judge Birmingham, again, this one keeps scratching my head. And this is the issue that I have with bringing up the 911 call with the quote unquote saying cheating whore. It seemed like such a stretch. And we were talking about this during the break. I know we both like watching the NBA finals. It seemed like a situation where a player has a completely open breakaway. You could do an easy layup, easy dunk, but instead they want to get up there, twist in the air, put it between their legs and throw it down. I'm like, if you miss by a centimeter, you're going to miss those 2 points. And that, to me, was that 911 call the cheating whore. Because I don't know if everyone agreed it was there. If they had someone analyze it and they analyze it and it's not there, that, to me, is grounds for an automatic overturn of the conviction. And you've got to do a retrial where you could have left it out and you probably still would have got the conviction. What did you think?
Well, first of all, shout out to Luka. He's amazing. I'm glad he's in Dallas, and I love talking about basketball. But yes, you know, you don't want to ever oversell anything as a prosecutor or as a defense attorney. You want to maintain your credibility with the jurors as a strategic thing, but then also you have to be considering these cases in the long term on appeal as well. So what's going to happen? What's going to become of this? It was a hotly contested issue in the trial. Jurors could have believed or not believed it said what it said, or it said what the prosecution said that it, you know, that you can hear from the tape or not. In those hotly contested factual disputes like that, well, that's why we have jurors. And it's a very high burden to overturn something. First of all, the court has to be convinced that that piece of evidence was inaccurately described, okay, that it did not say what the prosecution said it did. And then you have to consider that piece of evidence not just in a vacuum, but relative to all of the other evidence that was admitted in the trial. What were the other facts and circumstances that were admitted before the jury that indicated the defendant was guilty? Now, this does play into whether or not it was a good idea to admit or concede that this was a murder as opposed to an accident or something like that. So these issues are all intertwined, to be sure.
Yeah, and it seems that they're trying to really, we use the analogy in the past, kind of a bundle of sticks, where they're saying, okay, the defense attorney, and obviously this is not the same defense attorney making this argument that was in the trial. So the previous defense attorney did A, and then they shouldn't have done A. And then the prosecutor did B, and then the judge did C, and then this expert did D. And I guess in that bundle of sticks is where you're really making that argument that there should be a new trial. Do you think that there maybe needs to be a little bit more collecting of sticks to really make this argument strong, Your Honor?
Well, of course, and that's the burden, and that's what we're going to see in these different hearings. The judge sort of hinted at that. You know, they were asking for a trial, a new trial during right before the sentencing phase, and he talked about how this is a post-conviction issue, which is true. So there's going to be a development of the record, a collection of those sticks, as you said, in the days and months to come, probably, before they would overturn a jury's verdict. The law very much disfavors overturning a jury's verdict. We do favor finality, and especially we give a special weight to when juries resolve factual issues in a certain way.
Yeah, absolutely. Well, we'll see how this plays out. Obviously, there's going to be an appeal. I should have guessed, Judge. Like you're used to seeing the impossible shot go in with Luka Doncic over there. So maybe this does go in for the prosecutor. Maybe it does work out, but we'll see how it works out on the appeal. We'll be back with more after this break. Welcome back. So it's a continuation of the college admission scandal. If you're counting, we're at 57 defendants and counting, because this doesn't seem to be a case that has any end in sight. Because now we're talking about Amin C. Corey. Now, he's indicted for 2 counts, one of conspiracy to commit mail fraud and another for honest service mail fraud. What the feds are accusing him of is flying down to Massachusetts to try to pay off someone in the tune of $200,000. Now, $180,000 of those dollars would go directly to the school to try to get his daughter into the tennis program, while the other $20,000 were a kickback for a finder's fee to the third party. Now, the defense is saying that this has nothing to do with the college admission scandal and is saying that his defendant knows nothing about this. This is simply an honest way of trying to get his daughter into Georgetown. Now, she was a tennis player. It's a slight difference than we're hearing from other situations like that of the Lori Loughlin case. However, the federal government is saying that this athlete was not of the caliber of a tennis player that Georgetown typically recruits. So this seems to be maybe not as much of a complete makeup, but definitely making up some of the skills she may or may not have had. We're again joined with Judge Birmingham. Judge, talk to us about this ever-growing case where we're literally seeing one defendant after another after another.
Well, it may never stop growing. I mean, one of the things that struck me when we first started talking about it is that, you know, at first there was a few, and then the few became more, and now you've got 57. And the 57, you know, they may have information that leads to more and more. So it leads me to conclude that we may not be finished yet. It also kind of underscores something that I think is a real problem that's going on right now. And there's the belief that there's the haves and the have-nots. And especially when you're talking about, you know, college admission and going to the best schools and being able to pay. And I mean, you know, Brian, I'm still paying for my law school, and I will be for forever. You know, it seems like I think I've got 10 more years to pay for those loans. But the idea that, you know, college admission and a person's future is bought and paid for, people in America, they just don't really like that, not at all. And that's why this story, I think, is catching so much attention. And it's so far reaching. You know, I was a tennis player in college. You will be able to prove whether or not somebody was a recruit, especially of the caliber like Georgetown University. But it's impacted people that I knew and people that I played against when I was in college. And, you know, this just rubs people the wrong way.
Absolutely. I mean, you could be anything. I mean, I played D1 and D2 soccer, and I know the hours that went into me even getting looked at by a coach, let alone getting a scholarship. And now you have someone who can just slide in. It really kind of hits you in the gut no matter what. And even if you're not an athlete, you're still thinking the same thing, that the haves are coming in and taking from the have-nots, or those who put in hours upon hours upon hours of trying to hone their skills to help pay for their education. Again, we're joined by Jennifer Shen as well. Jennifer, as you see this case grow, we talked about Lori Loughlin and her husband, and now we're going down to the lesser-known defendants. What do you make of this growing case?
Well, I actually have 4 college-age students, and so I've been working with my kids for their entire lives. They've been working so hard in their grades and their testing and their athletics, and they do all of this work to get into good colleges. So it really strikes at me as a parent who has to pay for 4 children to go to college, that it's just not fair. And I think it sets a really good example. And in this time in particular, setting an example of, you know, you can't cheat your way into these things. You can't cheat your way into the best colleges. You need to earn it, and you need to have done the work to get there so that when you're there, you'll be successful. I think it's really great that all of these parents are having to answer for what they've done. And I think they should do that from the most high profile down to the least high profile. I think it really strikes at the hearts of all parents who are putting their kids through school.
Yeah, and Jennifer, I'll stick with you as the parent here who's doing an amazing job of putting 4 kids through college. Like, God bless you on that one for sure. Yeah. But it also feels like salt in the wound, because they could just pay this. In my mind, just pay the money to the school and get a free spot. Why do you have to take an athletic spot from someone who's probably way more deserving and way more needing of it? That seems like a little bit of salt in the wound rather than just getting a different position in the school. What are your thoughts on that?
It makes it even more offensive. I mean, it honestly makes it even more offensive that they have the money to do it and they don't. So it takes, I just can't even understand it. I really cannot.
Yeah. It's something that I think this is the reason why we might not ever see a trial, because you're never going to find 12 people who are going to be impartial on this, because it is such a punch to the gut for so many people, regardless of your socioeconomic background, your race, religion, creed, geography. You hear this and you think, look at what you took from someone else when you had so much. I think it's something that's going to disgust a lot of people and might be very hard for them to get a trial, and probably why they're taking so many pleas. Judge Birmingham, Jennifer Shen, I want to thank you all for joining us. Thank you all for coming. Make sure to check out our regular scheduled program after this, and we'll see you later here at the Law and Crime Report. Have a good day.